Assalamualaikum and salam hormat everyone. So inshallah today we will continue our syllabus on principles of industrial relations in Malaysia with topic 7 on trade dispute resolutions and direct actions. Basically, there are three major components for this topic, which are the first one, we will learn about trade disputes, followed by direct actions, and lastly, we will see on what is the role of the industrial court in Malaysia in handling the industrial dispute. First part, basically this is what we are going to cover in trade disputes. First, we will try to understand the meaning and examples of trade disputes as we can see in Malaysia. Second, we will explore the several factors contributing to trade dispute. Once we have understood this, then we will explore the methods to resolve trade dispute and methods explicitly stipulated in the Industrial Relations Act 1967. Last but not least, if the common method doesn't work, then what are the other resolution method practiced in industrial relations? Trade dispute can be defined as any dispute between employer and his employee in relations to the employment or non-employment issues, sometimes about the conditions of work and more. It is also called as industrial dispute. In Malaysian cases, most of the issues in trade dispute is about the dismissal of employees and termination, and to a certain extent, it is about the collective bargaining and collective agreement. This is the court case to explain about the Kuantan Beach Hotel Sdn Bhd versus Kesatuan Pekerja-Pekerja Hotel, Bar and Restaurant Semenanjung, Malaysia. This case shows the right of the trade union to organize trade dispute activity or industrial action such as strike or picket as a result of the trade dispute. There are several factors contributing to trade dispute, or sometimes we call it as the causes of trade dispute. The first one is related to employment or employment matters. The first one is if the failure of the all grievances procedure to conclude satisfactory results between the employers and the trade union. Second one could be the different opinion of the term and condition in relation to the employment, because the interpretation of Employment Act sometimes could vary from between the employer and the employees. The third one, a difference of opinion as the interpretation of collective agreement or industrial court award. So that's the reason why we have to make sure that during the collective bargaining session, the interpretation of the document or proposal in collective agreement should be clear and understandable by both parties, employer and the trade union. Fourth, the non-implementation of agreement or award, especially for the collective agreement. The refusal of any party to commence to a court recognition in the case of when the trade union apply for the recognition from the employer. Six, disciplinary action taken by the employer which are considered as unfair to the employees. We also have the non-employment matters which can cause for trade dispute. The first one, individual grievances, unfair disciplinary actions, violation of rules, late of work, and then misconduct, indecent and rude behavior of the employees or the employer perhaps in their relations, and also discrimination on job assignment. There are usually the main causes of trade dispute in Malaysia particularly. The first one is misconduct of the employee in relations to employment or non-employment issues such as promotions, welfare of workers, and etc. Second, unfair dismissal such as termination without notice or without compensation. Third, non-compliance to industrial court award means in certain cases and dispute, the industrial court already ruled and decided or award the decision, but either party such as trade union or employer refused to abide or comply with the decision made by the industrial court. Fourth, in many cases, interpretation of collective agreement sometimes conflicting between employer and trade union. In such cases, it may lead to industrial dispute such as the increment of salary, years of collective agreement to be effective, and etc. This is another example of court case on industrial dispute between KFC Technical Services Sdn Bhd versus Industrial Court of Malaysia. So in this case, the trade union applied for recognition, but the employer challenged the validity of the trade union membership and sought on advice from the Director General of Industrial Relations. You know why? Because the employer can actually question about the validity of the trade union, such as the membership, the what we call the constitution and etc. However, before the Director General of Industrial Relations could investigate, the employer already fired the employee who were the members of the union. This is against the Industrial Relation Act provisions and contravene with the IRA. So the company needs to reinstate all the affected employees back. This is the statistics of the reasons why trade dispute might happen, such as the first one, refusal to commence collective bargaining. Secondly, deadlock in collective bargaining. Thirdly, disputes over terms and conditions of contractual terms in collective agreement and other service contracts. Fourthly, retrenchment and layoff. Fifth, promotion, allocation of duties, transfer and other management prerogatives. And sixth, demotion, suspension, warning letter and other disciplinary actions against worker. This is another case that explains how the industrial dispute resolutions can be illegal if it has not been done according to the provisions of law. Raja Mohan has influenced other workers to do strike due to their dissatisfaction on working conditions and pay. Unfortunately, the action was against the law because to conduct strike, we must follow the procedures stipulated under the Industrial Relations Act. Now we will look at the method to resolve the trade disputes. It can be done through voluntary, or if it cannot be done willingly by both parties, it might be brought to the higher level such as Director General of Industrial Relations or Industrial Court. If the trade dispute happen, any party, either the trade union or the employer, can submit a complaint to the Department of Industrial Relations with the intention of seeking for a resolution. Three methods can be done: direct negotiations, conciliations, arbitration by the industrial court. As you can see, this level is stage-by-stage process due to the cooperation from both parties. The first approach is direct negotiation. It means that both parties, trade union and employer, are willingly and voluntarily meet together to resolve the problems of trade dispute which I have explained before. Please take note that the meeting is to be organized without intervention by third parties such as consultant, officers for Department of Industrial Relations or Industrial Court. Second approach is conciliation. In this approach, both parties, trade union and employer, meet, but with the involvement of the third party, which is officer of Department of Industrial Relations. However, the involvement of the officer of Department of Industrial Relations is only to arrange the meeting and observe the discussion. The officer of Department of Industrial Relations can only give some advice due to his expertise and experience on that issues discussed, but the decision is up to the parties involved in the trade dispute. There are some advantages and disadvantages for conciliation. The third approach method to resolve trade dispute is arbitration. It means that both parties are forced by the law to accept any decision made by the third party. The third party here is Department of Industrial Relations or the Industrial Court. But the third party is not simply made the decisions. They have to investigate the issue by examining the facts, data, documents and information collected from employer and trade union before they made the decision. This is the facts of the case on Palmex Industries, Sdn Bhd and the trade union. The case explained the stage-by-stage process in trade dispute resolutions by both parties, from negotiation to conciliation and to arbitration. Other than the three main approaches in trade dispute resolutions, there are another two methods can be used. Fact-finding machinery. Fact-finding machinery is the sub-process under arbitration. In order for the DGIR or IC Industrial Court to make the decision, they should have adequate and reasonable information. Thus, fact-finding machinery will help the authority to make just and fair decisions. The Minister of Human Resource, with the advice of the Director General of Industrial Relations or Industrial Court, can establish the Committee of Investigation or Board of Inquiry. Both machineries has quite similar function to investigate the issue and case, collect all the data and information and submit their findings to the Minister for the decisions. It's just that Board of Inquiry has more power compared to the Committee of Investigation. The mediator is the additional approach that can be used in a trade dispute resolutions. It's just like the conciliation, but the difference is the third party involved in mediator is not from Department of Industrial Relations or Industrial Court, but the third party appointed by employer and trade union is not from the government. For example, the legal firms, consultant from agencies. However, both parties must collectively agree upon the appointment of this mediator. This is the example of the process in trade dispute and resolutions process. You may find this from the website of Department of Industrial Relations Malaysia. It started from direct negotiation, conciliation, and arbitration. This is the statistics on the trade dispute dealt from 2017 to 2021. As we can see, most of the cases can be resolved by conciliation. Next, we will move to the industrial actions. These industrial actions usually happen when there is a deadlock in industrial dispute. When there is no solution from both parties, it can end up with industrial actions. According to Salomon 2000, industrial action includes temporary suspension of normal working arrangement initiated unilaterally by employees, whether through their union or not, or management with the aim of exerting pressure within the collective bargaining process. This is the most controversial issue in industrial relations. Some have pointed out that the threat of industrial action can lead to negative consequences, such as abuse of power. There are three direct actions under industrial actions. Picket and strikes are organized by the trade union or employees, while the lockout is organized by the employer. We start with picketing. The most common form of industrial actions by employees is the picket. The law allows picketing. According to Section 50 of the Industrial Relations Act, workers are allowed to picket at or near their workplace, usually during lunch hour or after working hour, when they have a trade dispute with their employer for the purpose of giving information to the public and other workers, and to persuade other workers not to work if a strike has been declared. Picket lines, however, cannot intimidate anyone or cannot obstruct the entrance and exit of the work premises, and also must be peaceful. Who can participate in picket? Workers who are directly involved in the dispute and a union officer. To make sure that the picket goes in accordance with the law, a police permit is not required for picketers if they follow the rules and regulations of picketing. It is a legal activity which the police has no power to disperse. Pickets are used to publicize an issue to the public and thus embarrass the employer. This is done through the use of banners and placards with disparaging statements about the company. The picketers might gain public support by giving statements to the mass media. The public who witness the picket might show their support by honking and horns from their vehicles. Another example of a picket was by 2,000 Syarikat Telekom Malaysia employees over a bonus payment. They gathered in front of the headquarters during lunch breaks and after working hours in 1998. In 1999, when the issue of bonus payment arose again, it was settled before a picket was held. This is the picket organized by the union based on industry. It is commonly organized by the agriculture, forestry and fishing, followed by manufacturing industry. Another statistic on picket by industry. The continuity of the statistic on the picket by industry. This is the cause of industrial actions. The common reason reported here is the dispute over terms and conditions of contractual terms in collective agreement and other service contract. Next, we move to strike. Strike can be defined as the cessation of work by a body of persons employed in any trade or industry acting in combination, or a concerted refusal or a refusal under a common understanding of any number of persons who are or have been so employed to continue work or to accept employment. In other words, a strike is any stopping of work by a group of workers, including slowing or limiting production on purpose. Therefore, any slowdown tactics, even though the workers are still working, such as go slow, work to rule, or a ban on overtime that results in a reduction of output are considered forms of a strike by the Industrial Court Award number 28 of 1975. But strikes are not encouraged as they are a method of undermining stability, according to the Industrial Court Award number 35 of 1987. This slide explains on the procedure before you can organize strike. Basically, you need to take place if two-thirds of those entitled to vote agree to the action and after waiting 7 days, or what we call cooling off period after the ballot results have been sent to the Director General of Industrial Relations. But anyway, you have to remember that workers in the essential services such as banking, transport, post, public health, and etc. must not only fulfill the above requirement but also must give their employer notice of their intention to strike. Above all, either strike or picket must follow the procedures before you can implement any of these industrial actions. Secret ballot is essential for strike, but you must get at least two-thirds majority before you can do strike, and those who can vote is only the eligible ones. This slide explains about the provision to declare legal strike as stipulated in Trade Union Act 1959. So the trade union, if they want to organize strike, they must get at least two-thirds consent through secret ballot. Then they have to submit the secret ballot result to Director General of Trade Union within 14 days, and the trade union has to wait for 7 days cooling off period for the employee to respond with the issue, and also for the trade union department to respond with the issue. The GTU shall conduct the investigation to check the membership of the trade union to make sure that the secret ballot implemented by the trade union is actually legal. Strike must be declared before the expiry of the secret ballot, and strike cannot be declared if the case is already referred to Board of Inquiry and Industrial Court, if the matters regarding dispute are included in the collective agreement that has been given approval by Industrial Court. There are several conditions that prohibit a trade union from declaring strike. The first one, in the case of trade union, without first obtaining consent by secret ballot of at least two-thirds number of members entitled to vote before the expiry of 7 days after submitting the result of secret ballot to Director General of Trade Union. Also, not permissible for the trade union to organize strike. Trade union also prohibited to conduct strike in the case of if the secret ballot for the purpose strike lockout has become invalid, or in contravention of without complying with the rules of the union as stipulated in their constitutions. And also they are prohibited to organize a strike in respect of any matters covered by a direction or a decision of the minister given or made an appeal to him, as well as if the intention to organize strike is contravened or without complying with any other provision of Trade Union Act 1959 or any provisions of any other law. This slide explains about the circumstances required to take secret ballot. In the case of election of delegates at the general meeting, the election on officers by the members, all members relating to strike and lockout, the imposition of levy, amendments of the rules, dissolutions of trade union, and also amalgamation with other trade union. Industrial actions not only limited to the employees and trade union. The employee also has the right to organize industrial actions, which is called as lockout. It can be defined as the closing of workplace, the suspension of work, or the refusal by an employer to continue to employ any number of workers employed by him, in furtherance of a trade dispute done with a view to compel those workers to accept terms and conditions of work. The objective of lockout is to force the employee to accept the employee's demands, such as in collective bargaining or content in the collective agreement. The worst it can happen due to the closure of a factory or plant is it might lead to loss of employment for the workers involved. We might think like how the employee can survive without the employees if the employees are locked out. The action taken by must when the employer can also took steps such as replacing workers with other workers while they are on strike. The strikers can be replaced by managers or non-union employees. The strike might stop sooner and the strikers might go back to work if they feel that their action is not effective enough in hurting the employer economically. An example that can we draw upon is when the Malaysia Airlines system brought in Dusun Tour trainees to replace cabin staff who were on strike. They were trained thoroughly to replace the staff. This is the court case to explain about the implication of illegal industrial action by the trade union. If the trade union organized the picket or strike without following the procedure, so the action taken by the employer to lock out is considered as legal. These are the effects of industrial actions on employer. If the trade union organized industrial actions, this will definitely affect the productivity of workers, especially when the employees organize strike. This will then indirectly lead to loss of profit when employees are not productive or not attend to work. The profit of company will also be affected when the reputation of the company drops in the eyes of the stakeholders, for example, shareholders, financial institutions, government, customers, and etc. In one scenario, it will lead to the closure of company when it suffers continuous loss and bad reputation and image. In the case like British Airways Company, when the trade union organized a strike, it impacted the company directly and to the economy of country indirectly in terms of business, tourism, tax, and etc. The industrial actions may also affect the employees. In this case, if the employees involved in picket or strike or perhaps lockout, the income will be affected when you are no longer having any overtime job. Even worse, if in the case of lockout, employees might lose their salary and lose the job in the end. The industrial action will also lead to low motivation when employees already feel unhappy and dissatisfied towards the work they performed in the company. Now, we will move to the industrial court subtopic for topic 7. In this part, we will discuss on the background of industrial court, proceeding involved in industrial court, and what are the jurisdiction of the industrial court. As we can recall, in trade dispute and industrial resolutions method, industrial court will come in place when there is no way to settle down between both parties in harmonious ways, such as direct negotiations or conciliations. Industrial court will involve in arbitrary process by giving the order or award on the decisions to resolve the conflict or dispute among trade union and employers. This is the structure of industrial court. It is headed by the president appointed by Yang di-Pertuan Agong, and he or she will be assisted by a panel of persons representing employers and the panel of persons representing workmen, all of whom shall be appointed by the ministers. This is the power of industrial court during the proceedings. It means the power of industrial court when handling that case bring to the industrial court. Firstly, industrial court can order any party, either trade union or employer, to join, to replace them, or to strike off for the proceedings. Secondly, to summon or call either parties for such proceedings. Number 3, to take evidence on oath. Number 4, to hear and make sure industrial court can obtain the written statement from either parties for the proceedings. Number 5, to conduct the proceedings in private if necessary. 6, in the case referred to the minister, the industrial court can call or seek an advice from more experts. Number 7, to make an instructions or implement anything that is necessary for the benefits of every parties in trade dispute. These are the jurisdiction of industrial court. Industrial court is responsible for two types of cases. The first one, cases related to issues on dismissal, trade dispute and victimization which referred by the minister based on the complaint lodged by any parties of trade union or employer. Secondly, direct applications to the industrial court in the case of non-compliance of the award or decisions or instructions made by the industrial court on collective agreement. The conflict arose between employer and trade union in the case of different interpretation of the award in collective bargaining and points of law that perhaps lead to conflict of misunderstanding to interpret labor law such as Employment Act, minimum wage legislation, and etc. There are 9 situations where the industrial court can make decisions. Award here means decisions. Firstly, industrial court has power in relation to trade dispute. Secondly, the industrial court can make a decision based on the majority of the members or the president himself. Thirdly, the court should make decisions or award within 30 days without further delays in relation to trade dispute. Fourthly, the court should consider the public interest before making an award or decision on trade dispute, taking into account on the financial, economic, and social impact to the industries and country. Fifth, the court shall act according to equity, good conscience, and the substantial merits of the case without regard to technicalities and legal form. Sixth, the industrial court should remain fair and just in making an award or decision in trade dispute. 7. The court should also be specific in mentioning about the period and duration in the case of trade dispute. 8. The award should be signed by the president to make it legal and official, but in the case of his/her absence, the chairman of any division may take over the duty. Ninth, the court may rectify in any award on any clerical error or mistake arising from the accidental slip or omission. These are the limitations of industrial court. We have to remember that the industrial court is not a court of law. In the case of any questions of law arose in its proceedings and decisions is affected or challenged, the question may be referred to the higher level, which is the High Court. The industrial court is subject to the jurisdiction called as judicial review. So that's all for topic 7. I really hope that you are now have better understanding on what industrial dispute is all about, the types, how it happened, and what is the implication. The industrial dispute may lead to industrial actions if the things getting ugly and worse. So there are several methods in handling trade dispute. Finally, I hope you can understand the role of industrial court in handling trade dispute in Malaysia. Thank you and have a good day.